Good afternoon, ladies and gentlemen. Thank you for joining us again at the Santa Fe District Court, where this morning we heard the opening arguments, both from the state and from the social media company Meta, about the state's outstanding public nuisance claim and the arguments that we anticipate making over the next several weeks, outlining not only the public health harm to the kids here in New Mexico, but more importantly, the specific design changes that we are seeking to have the court order in response to what I think has been a profound public rendering of all that we have learned over the last couple of years. For those of you who've been following this case for some time, we had a 6-week trial where we uncovered and brought before a jury a horrific number of facts about the way in which Meta's social media platforms, Instagram, Facebook, WhatsApp, have built-in design features that lead directly to profound psychological and physical harm to our kids. We also had an extraordinary trial presentation about the way in which that platform facilitates and amplifies sexual exploitation. I am proud to be joined here today with members of Parents Rise, a group who sadly is all too familiar with the profound impact and the real world impact that this technology has brought to bear on our communities, not only in New Mexico but around the country. So I'll be asking each of them to step forward and talk briefly about the experience that has impacted their families in ways that are unimaginable. We are also happy to be joined by a member of our faith community to talk about why it's so important that the state of New Mexico continue to stand as a beacon for accountability against big tech, against executives like Mark Zuckerberg, who continue to place profits over our kids' safety. And so with that, I'm going to ask them to step forward and provide some context. And then I will come back and answer any questions that you may have about the ongoing proceedings that we have just witnessed here this morning. So joining me are Shannon Heacock, mother of Elijah, Jen Marcus, mother of Braden, Juliana Arnold, mother of Coco, and Tamia Woods, mother of James. We will also hear, as I mentioned earlier, from Reverend Kathy Salazar. And with that, I would ask for your patience in listening to what I think is what has brought all of us here today to this courthouse, because this is more than whether or not we can force a tech company to change its algorithm. It's more important and more impactful than any dollar amount, frankly, that can ever be ordered by this court. It's about saving kids' lives. It's about saving families. And no one can speak to that, I think, more passionately and with more force than these families. And so I'd like to start with Tamia Woods to step forward and say a few remarks, please.
Thank you, Attorney General Torrez. I am deeply disappointed in Meta's platforms with their failure to protect our children. My son, James Woods, he's not a headline. He is my child, my only child, and he was a victim of financial sextortion. He received 200 messages by 4 different people in 19 and a half hours. And because of what happened, I no longer get to hug him, cheer for him, or see his smile. I live in moments now, moments of memories instead of moments of presence. What makes this even harder is knowing that these dangers were not unknown. There were clear warnings, clear patterns, and a complaint that was filed and served to Meta on November 15th and 16th of 2022, and yet nothing changed. 3 days later, my son was gone. Meta took down the pages that attacked my child and similar pages without a subpoena. They knew they were wrong. These platforms present themselves as safe for our youth, while at the same time collecting data, amplifying engagement, and exposing children to people who are actively looking to harm them. When profit is prioritized over protection, the consequences are not abstract. They are devastating. They are permanent. This is not just about my son. This is about every child who logs online not knowing that they are in danger, and every parent who trusts these companies that they are doing everything in their power to protect them. Misleading consumers and failing to protect children should have consequences, because behind every statistic is a family like ours, forever without our children. I stand in solidarity with Jennifer Marcus, Juliana Arnold, Shannon Heacock, Attorney General Torrez, and the new state of New Mexico to demand change, require online protection, investigate, follow through, and act on reports of child sexual exploitation, redesign algorithms used by children, and accurately disclose the potential harms of meta products. These requirements should always be non-negotiable. I share this not just from a place of pain, but from a place of purpose, because our children deserve better, and we will continue to fight until they get it.
Hello, everyone. My name's Juliana Arnold. I traveled here from Southern California. As we know, I am a survivor parent. I lost my daughter, Coco, to social media harms. And the past few months, I've been very involved in the trials. And, you know, we've seen two juries find that Meta's products are dangerous for kids. And that's not just an opinion or a story. It's the evidence now. And the evidence shows that they knew what they were doing. They knew about the harms. They knew predators were on their platforms. They knew they were designing their platforms to be addictive, and they didn't do anything. And now, you know, instead of fixing it, you know, which we're asking them to do, they're threatening to now pull out of New Mexico. That's their answer. And it's just not acceptable. You know, it's like a company choosing to protect its business model instead of doing the right thing and protecting children. So here's our question. Which of these protections are not possible? I mean, removing features designed to keep kids hooked? Stopping adult predators from finding and messaging children they don't know? Or building real safeguards into the product instead of engagement at every cost? Why can't they just call a recall? You know, fix the harms, protect kids. Every other industry has safety standards, and it's just common sense. And let's be honest about something. They already have the technology. They already have the technology. They do it with copyrighted items. They have what they need in order to make this happen. And I want you to know this is not just theoretical for me. My 17-year-old daughter, Coco, was found by a predator on Instagram. He groomed her, he gained her trust, and he sold her what she thought was a Percocet. It was fentanyl, and she died, and she had been sexually assaulted. Now, 4 years later, my older daughter is graduating college in 2 weeks. She graduated just weeks after high school, just weeks after Coco died. Coco will never graduate high school or college or have any of those milestones. And her sister will never share a life with her only sibling. You know, I don't want to be here. None of us parents want to be here. We didn't choose this. And it's not how we plan to spend our lives. But when the alternative is more children dying, we feel that there was no choice for us. And that's why we're here. And all we're asking for is simple. Remove harmful features designed for safety. Stop putting kids in harm's way for profit. So point blank, Meta knew their products harm children, and they're choosing to continue to do this because it's profitable, and no one has tried stopping them until now. So I want to thank Attorney General Torrez for his courage and his leadership. We need more leaders to take a stand and protect our families. And for parents, it's time to speak up. Reach out to your community, state, and federal leaders and tell them enough is enough. Let's take back our kids' childhood before it is too late. Thank you.
Hi, my name is Catherine, Reverend Catherine Michelle de la Rosa Salazar. I am an assistant principal at a school in Albuquerque, and I want to thank the Department of Justice for inviting me here today and inviting me to share at the trial. Today I'm speaking as an educator, a parent, and a community member who has seen firsthand how social media platforms are harming children, especially children between the ages of 10 and 16, as well as our vulnerable adults. In my service to the community, I have witnessed many harmful behaviors being done by and to children. I have seen the harm caused by secret accounts, anonymous bullying pages, harmful group chats, predatory contact, threats, exploitation, and the sharing of dangerous content. These are not abstract concerns, they are real behaviors affecting real children, families, schools, and our communities. While parents and caregivers have a responsibility to monitor their children's online activity, and many are trying, social media companies also have a responsibility to make sure their products are not damaging or dangerous for children. Reasonable changes can and should be made. Children should not be able to create multiple or secret accounts. A child account should be connected to a verified adult account, and that account should have real authority over their contacts, followers, and privacy settings. If a parent or guardian does not approve a contact, that person should not be able to follow, message, or interact with the child. Platforms should also limit notifications to children, especially during school hours and overnight. No child needs to be pulled into a device, especially for conflict, bullying, or harmful content at all hours of the day and night. Images, videos, and statements involving self-harm, threats, bullying, sexual exploitation, drugs, alcohol, or violence should not be allowed to circulate. When harmful content is reported, it should be paused immediately and meaningfully reviewed. If these companies can detect copyrighted music in seconds, they can invest in detecting predatory behavior, child exploitation, bullying, and threats of harm. Group chats also need real safeguards. They should be monitored for bullying, exploitation, and illegal activity, especially when minors are involved. Children should not be left alone in digital spaces where adults and peers can manipulate, threaten, shame, or exploit them. Our state has already moved forward in holding Meta accountable. And as the public nuisance phase continues, it is clear social media companies cannot continue to profit from systems that harm children and then place the full burden upon families, schools, and our healthcare systems to clean up their damage. Our children and vulnerable community members deserve safety, dignity, and protection online. These are not extreme demands. They are fundamental, reasonable changes that can help protect children, support families, and make our schools and communities safer. Thank you.
So I just want to thank again the parents and community members who've joined us here today. I think it's incredibly important for people to understand that even though inside the courtroom and inside the courthouse, we're going to hear an extended debate and legal argument about federal immunity law or whether or not a particular injunctive demand is feasible. But what should never get lost is the human dimension, the pain, the anguish of parents who have seen a loved one, a child's life cut short, to have them victimized, and to recognize that we should never be in this place. This is not a situation that happened by accident. This is something that, as the jury said back in March when it reached its original verdict, these were willful violations. This was a company that knew what it was doing when it built these products. It made intentional design choices. Oftentimes, those design choices were specifically identified by whistleblowers inside the company. They were flagged for action that could have been taken by Mr. Zuckerberg or anyone else. And because of profit, because of money, a choice was made to place these families and these children at risk. That should never, ever happen. And I want members of the media and members of the public to understand something else. The era of treating big tech differently than we treat everyone else has to come to an end. If there was in Santa Fe right now, a physical space or a physical warehouse where members of the community could come and understand that they could buy and sell and trade pornography or trade human beings or sexually exploit children, there would be an immediate outcry. There would be demands for a criminal investigation. We would be going into that physical location with police officers. We would be taking people out in handcuffs. We would demand to know who rented that building, who owned that building, and we would demand as a community to hold those people to account. And yet, because of the origins of this particular type of market and the fact that it has so much lobbying power in Congress, that it is by far the most lucrative, the most well-resourced lobbying power in America today. That's why we can't get federal legislation to fix what we are trying to fix inside of this courtroom. I agree with these parents. Enough is enough. The state of New Mexico is not going to wait. We are not going to stop, and we are not going to slow down one bit to protect our kids. And I know that there has been a lot of coverage in the last several days leading up to today's hearing about a threat that Meta made recently about withdrawing from this state. A couple of points to make on that. First, that's a choice. That's not something that's being imposed on them, but they can make a different choice. The choice, instead of leaving the state of New Mexico, is to listen to the state of New Mexico, to listen to our citizens, to listen to the jury, and respect what they have said about the law, and expect what they have said about our expectations for how they conduct themselves as a business, and what kind of choices that they make. They know how to build a safe product, and if they don't, we will show them how to build a safe product. None of the things that we are asking for are either technically infeasible or impractical. They're simply expensive decisions for them to try and undertake, but they are well worth it to try and create an environment where everyone's families can be safe and secure. This is a company that spends tens of billions of dollars every quarter trying to build out in its arms race for artificial intelligence, and it wants this court and this state to believe that it doesn't have the resources or the technical capability to build a safer platform. Nobody buys that. I don't think this judge is going to buy it. I know that the jury didn't buy it, and I think what we're doing here is going to change expectations not only for how this business operates in the state of New Mexico, but how big tech generally is expected to operate all over the world. This is an important and historic first step, but we are just getting started. And with that, I'm happy to answer any questions that you may have.
Before we open it up for questions, I just want to say two things. Number one, Danielle's got a little mic that's going to go into the computer. She's going to bring it around to everyone. And number two, we have a couple people up here that didn't have the opportunity to introduce themselves yet, and I wanted to open up a chance before we get into questions, if you guys would like to speak quickly. Take as long as you like.
I'm Jen Marcus, proud mother of Braden Marcus from Ohio. He's forever 15, and he was sextorted back in October 17th, 2021. As everybody else here has said, it's just a matter of changing things. In our personal case, it went down in 27 minutes. From start to finish, somebody from overseas was able to, as everybody knows, create an account, pretending like they were a girl from his school. Clearly was not. There is no reason that an adult in another country had access to even gain access to my 15-year-old son's account. If we're on the Facebook world and I make some ignorant comment on there, Meta has no problem, deleting that comment quite quickly, but you can't shut down threads for all these families. And there's no reason why on the messenger side that these threads are not being shut down. Like when a kid says it over and over again, I'm only 15 years old, why are you doing this to me? I will just kill myself. That thread should have been shut down from the get-go. So Meta has clearly they're not serving this country. So they need to make change, and they need to make it quite quickly before more kids. Unfortunately, kids are still dying as of this minute. So, but that's really all I have to really add. Thank you. That's on the spot.
Hello, I'm Shannon Heacock. I am the mother of Elijah Heacock, 16, forever, twin. Ours happened in 20 minutes. They demanded within 150 messages, AI photos, and $50. I have to go visit my twin in a grave. I do that often. I take his sister. She will become a senior in the next couple of days, and that's forever lost for both of them being together. I want you to know that it can happen in a blink of an eye. We get blamed often for not doing more. How are we supposed to know when I didn't know a year ago what sextortion was? I had no clue what it was, but now I do. And I warn others to try to save a child from ever being a part of what we've been through.
Thank you. We can open it up for questions. Danielle, your hand is first.
First, I have a plain question, and then I have what is a public nuisance case?
That's all right. That's all right. A public nuisance claim is a claim that is often brought by states around the country. The most sort of recent examples that you have seen relate to the opioid epidemic. And it effectively is a claim against a company that has created a specific harm to health or public safety based on the design or the operations of their business. It's a common law claim. It's different than the statutory claim, which was the emphasis and the focus of our first half, which was under the Unfair Practices Act. It's a consumer protection claim. The interesting thing about a public nuisance claim is if the judge determines, as we believe he will, that this product constitutes a public nuisance and that it has endangered and harmed public health here in New Mexico, we are then asked to quantify that harm and come up with an abatement plan. That abatement plan would, if ordered by the court, specify a certain dollar amount be dedicated as damages paid by the company to actually try and correct some of that harm. And in New Mexico, that would probably take the form of a broad public education campaign. So what you've heard and what you're sort of hearing from people who have been impacted by this is the company has a deep level of knowledge about the way in which their features are impacting kids and young people. Parents don't, and members of the public don't. So one of the things you would do with public nuisance funds would be to use those funds to help educate families and parents so that they can make better and informed decisions about that. But it goes much deeper than that. There are kids in New Mexico, like there are in every jurisdiction, who have social media addiction issues and mental health issues. We heard testimony in the first phase about increases in anxiety, depression, suicidal ideation. All of those kids need help. They need counseling. They need therapy. These resources can pay for those kinds of supports. That's why we're pursuing a public nuisance claim.
And then to follow up, any response to the skepticism from the judge about potentially becoming a one-man legislature?
Well, listen, I think the nature of this product is one that is unique, and he has a big duty in front of him in terms of trying to address the specific harms that we've already established in the first phase and that we intend to fully elaborate on in detail in the second phase. But this will not be the first time in American history that courts, exercising their inherent authority, have recognized that an injustice has occurred and stepped in to correct that injustice. In fact, it was in this very courthouse not that long ago where a different district court judge recognized the systemic underinvestments in educational resources for Native American kids and took it upon herself, and then that duty was passed on to a subsequent judge who was assigned to the case, to place binding requirements on the state of New Mexico itself to meet certain constitutional guarantees for what an adequate education would mean. So I understand and I'm sympathetic to the idea that it would be better probably for all of us, right? Especially for those who don't live in the state of New Mexico and don't have the benefit of an injunctive order in this state, for Congress to wake up, to see these verdicts and actually do something. I would love nothing more than that to happen, but in the absence of action at the federal level, I have an obligation to try and protect kids here in New Mexico, and that's what I intend to do.
Jessica with Channel 13. In regards to the whole public nuisance realm, we heard today in Meta's opening statements that this is something that's never been applied to a social media platform before.
Yeah.
How confident are you that that will fly in court and that the judge will side when it comes to the public nuisance idea on a social media platform?
Well, listen, a public nuisance claim wasn't applied to any opioid company until it was, right? There's always a first time for everything. I'm happy for the first time a social media company is held account for public nuisance to happen right here in a Santa Fe courthouse. Part of the problem and part of what Meta probably didn't say in their opening argument is that they've never had to face a jury like this, and they've never had to face a public nuisance claim because they've worked so hard in Washington to keep a shield up known as Section 230 so that families like these and states like New Mexico never get inside the courtroom. We never get to have our day in court. We get poured out on a procedural question. That thankfully didn't happen here, and that's what is so consequential about this case. So, I know Meta is likely to highlight the unique way in which they have been the first. But frankly, if they ran a more ethical business, a safer business, if they cared more about kids' safety, they wouldn't be here. So my sympathy for that, that argument doesn't really fly. I'm thinking about these families and what they've suffered.
And then I had a follow-up to what do you think is going to be your greatest challenge? I mean, it's day one for the trial, but what do you think is going to be the biggest challenge for this case compared to the previous Meta trial?
Well, look, the most significant thing at issue in this case is whether or not we are going to be able to convince a district court judge in Santa Fe to order one of the largest social media companies on the world to fundamentally change the way it does business, right? Those injunctive terms are meaningful, and they have to be, given the nature of the harm. So there's going to be, I would imagine, a lot of testimony about the technical feasibility of real age verification, or how you might alter the algorithm so that it doesn't surface child exploitation in the future. But just because something is difficult or challenging or requires expert advice or opinions is no reason to pretend that the harm hasn't happened or that there isn't an obligation on all of us to try and do something different. One of the things that I think is an important feature for all of you to be aware of is, and this goes to the earlier question about the judge being concerned about, his ability to navigate what is admittedly a very new space. We specifically have advocated and asked for the appointment of an independent monitor, and that independent monitor would be responsible for analyzing the technical implementation of all of the different changes that we've identified, and then working with the court and with the parties to make sure that they're actually in compliance and that the changes are leading to the kinds of outcomes that we want to have. In other words, we don't expect any district court judge in Santa Fe to sit and watch this company in each and every iteration as it implements each and every technical change. That's why we have independent monitors. But again, that's something that has happened in a lot of different courts, in a lot of different lawsuits across this country in various contexts. So again, that's not a new concept. It's just new for social media companies. And, I think the most important thing is if we get it right here, it's going to set a model for the rest of the country and the rest of the world. And that's incredibly important.
Peyton Spellacy with KOAT. When it comes to the injunctive reliefs, it's my understanding from the opening statements that the state has 7 pages worth of kind of changes that they want Meta to make. We've heard a lot about infinite scroll. We've heard a lot about age verification. You just mentioned the monitor. Is there anything else that we haven't really heard in the media that you think is important to mention, like another big change from those 7 pages?
Yeah, and so one of the things that we have focused in on in the first phase is the way in which sexual exploitation is actually amplified by allowing encrypted communications between unknown adults and young users on the platform, right? That's why we are asking the judge specifically to not allow strangers to communicate in an encrypted way with a child that they don't know. That will require some technical testimony and examination by the court. But given the scale of the harm that is caused by leaving an encrypted channel between strangers and kids, it just makes sense for us to take a look at that. The other thing is Arturo Bejar, in his testimony in the first phase, reminded the court that what these platforms specialize in is identifying what your interests are and connecting you with those interests. And if your interests lie with little girls, it will be very good at connecting you with little girls. There has to be a technical solution for solving that issue, right? It is absurd to believe that a company with this amount of technical know-how and the resources they have at their disposal are incapable of solving that problem. But those are the kinds of complex issues that are going to be under consideration here by the court. I think fundamentally, though, we have to start with the premise that this is a company that already operates under different rules around the world. Some of you may not know this, but the EU has a different regulatory scheme. Australia has banned social media for anyone under the age of 16. What does that mean? It means they're already working on age verification. They're just not doing it in America. They're already working on curating different forms of dangerous features on their platform. They're just not doing it in America. This company has a history of responding and reacting to authoritarian governments all over the world whenever their market access is jeopardized, and yet they won't modify this product in America for American kids. That's not going to make any sense. And I think when the judge hears about how often and how frequently they already change their platforms to comply with the laws in other parts of the world, he's going to be faced with one fundamental question: is if you can do it over there, why can't you do it right here at home?
Time for one more. Go ahead, Morgan.
We can take others. Yep.
Go ahead, Morgan, then Mike.
Yeah, it's kind of a broad question. Meta today was saying that you're asking for more than to fix the problem, that you're gonna build out a suite of, I guess, remedies that deal with the public health system and not just this case. And the other one was this idea they floated that this would be triple dipping somehow, that there's already unfair practices, that people have remedies like we've seen in California recently where they can get a settlement for tort or an award.
Yeah.
Can you address those two things, please?
Well, I didn't hear Meta concede in the court that they're totally open to individual plaintiffs coming into New Mexico to recover those claims. That might be a good question to ask Meta. If they're asking whether or not this is triple dipping, maybe they should be asked of whether or not they're going to oppose any families in New Mexico who bring a lawsuit because they're barred by Section 230. I don't think they're going to do that. So that goes to that question of triple dipping. The other thing is they are held responsible under New Mexico law for lying to consumers about known dangers in their products and failing to correct those dangers, and then misrepresentations that they've affirmatively made that keep people in the platform without their full awareness and knowledge of what's going on. And think of it this way. Has any one of you who have ever opened up a Meta social media platform, before you're allowed to proceed, have you ever seen a banner that says, be warned, if you're going to let your child use this app, they are at greater risk for anxiety, for suicide, for self-harm, for sexual exploitation? Have they ever disclosed that to anyone? We do that all the time with consumer products. Why don't we do it with one of the most dangerous consumer products in the world? With respect to the public nuisance claim, that is a special and unique claim that's advanced by the state of New Mexico and other states around the country when there is a demonstrated public health harm that we can quantify and we can come up with a plan to address that harm. The law allows it, and that is something that is a tool that I intend to use to its absolute fullest extent to try and make sure that we not only change this platform but have the resources we need to correct the behavior that's led to the harm up to this point.
Yeah, Mike Swift with MLEX. I know you were in Washington recently, and I'm wondering what you took away from that experience. Do you feel like these two verdicts here and in Los Angeles have started to move the needle in Washington at all?
Well, we had a very productive conversation both with Senator Durbin, Senator Hawley. I met with Senator Graham. What is interesting to me about this is that there are so many issues in this country that immediately divide into Republican and Democrat, into red and blue versions of a policy dispute. This is not one of those issues. There is broad bipartisan support here. I think, frankly, Congress has been stuck because of the lobbying power of big tech, because so much money is spent trying to keep that Section 230 shield in place. But I got a sense that the dam is starting to crack in DC, and that policymakers are bolstered in their efforts by what happened in Los Angeles and what happened in this courtroom, because what they're seeing is that everyday citizens and people at the state and local level are fed up and they want action, and if Congress won't move, we will take the lead. One of the things I did mention at the press conference with Senator Hawley and Senator Durbin is, look, I would love for a comprehensive national solution that builds in safety features for all social media platforms. Not only the ones that exist now, but looking down the road for artificial intelligence platforms and applications. I think that is a smart and sensible thing. But I'm not going to wait for Congress to decide that it's time to act. So if nothing else, reform, revise, or eliminate Section 230 and let us handle it in the courtroom. Because here's what happened. Whether it's Los Angeles or Santa Fe or even other communities around the country who haven't had their opportunity to go into court, you know what we've found out is when everyday people hear about the conduct of this company, they have an unequivocal and forceful message to send to big tech and to Meta in particular. Enough is enough. No more harming our kids. And if Congress won't take the lead, we'll do it for them. So that's my hope. That's my impression. My sense is that the more verdicts we have, the more pressure is added to Congress to actually come up with a solution. And I'm going to do everything I can to try to be part of that conversation as well.
One more before the court gets back in session. Does anybody have one more? Morgan, go ahead.
Can you specify the monitor that you're proposing? Would they be like a technical expert? Is it up to the judge to get into these things about what's feasible, what's not in terms of the app and the platform, or is it going to be up to this monitor? What are you proposing?
We are the way the appointment of a monitor works typically in litigation of this type is to find somebody with the requisite level of technical and educational experience to actually serve as a mediator and a translator of sorts between the court and its orders and the implementation and application of this technology in the real world. So we would be submitting for the court's consideration various individuals that we think meet that criteria and have the ability to keep an independent eye on whether or not this company is actually acting in good faith and in compliance. All right, thank you very much. We really appreciate it.